Okay, welcome everybody to today's webinar on basically on SMSF documentation. So, look, this is going to be a fairly rapid-paced webinar because I've got a lot of content for you or to share with you today, and it's really a lot of it is thought processes. So, whilst there's some technicalities associated with it all, it's really driving the key issues around, I guess, the primary SMSF documentation issues that we're confronted with. And given that my role at Smarter SMSF, where I deal with the education and technical side of things, is also a bit of an opportunity to show you how we can potentially help you out with your clients there and your documentation as well. So let's jump straight into it and work through our documentation needs and considerations when it comes to self-managed superannuation funds. So one of the things that I'll sort of highlight throughout the presentation as a bit of a theme is around the issue of the risks associated with various documents as such. I'm not going to spend any time today necessarily outlining the critical decisions of various court cases. Needless to say, has been plenty of court cases around, particularly when we talk about trust deeds, when we talk about binding death benefit nominations or the lack thereof, enduring powers of attorney. Probably the one sleeping giant for self-managed superannuation funds is pension documentation. So we'll touch on that obviously today as part of the process to work through a number of key issues. So really what I want you to get out of today is how the deed sort of drives a lot of what we're doing from a documentation point of view, the things that we need to ensure that we have, and then that leads into the documents that ultimately cause the greatest amount of conflict for most people along the way. And you know, we know this with regard to things such as binding death benefit nominations and investment strategies, but our need to regularly review our documents as we go along. So look, really, what you know, and we took this information. We took some or did a survey from one of our webinars back in 2021, and it's fair to suggest that that a lot of these numbers, whilst they might have changed a little bit over time, is we noticed that there's a lot of clients out there that do create their own documents. There are probably a third of SMSFs out there who will use a document provider. And then there's still quite a high percentage of people that will utilize the generic documents that can be provided through the SMSF software providers. And of course, the issue with the SMSF software provider documentation is that they can absolutely be used for certain things and fit quite nicely into, say, the annual trustee minute requirements as part of the financial statements. But when we start to talk about things such as pension commencements and lump sum withdrawals and other conditions of release, you want to be referencing your documents back to your deed. And because of the generic nature of the software provider documents, it does provide a bit of a gap in the technicality and ensuring that things are satisfying their requirements, sort of from both a compliance point of view, but also the deeds point of view as well. So, you know, there is really this need to ensure that whatever we're using from a documentation position, that it is going to meet the needs of the SMSF clients that we're dealing with. So what I've excuse me, what I've tried to do here is identify, I guess, from some of the key areas with regards to our documentation, some of the excuse me, sorry, some of the matters that are fairly important for us to have clarity on. So, you know, when we talk about our deeds and our other legal documents, and as I said, some of these I'll go through in far more detail. Some of them, this is probably the only reference I'll make through the presentation, but the deed is obviously a fairly critical part of today's webinar. But as far as the observations, the risk areas associated with deeds and other legal documents is that they might be ineffective. Sorry, excuse me about this. So the deed may be ineffective. There could have been changes to trustees. It hasn't been updated, not signed correctly. There could be other issues associated with it. There could be lost documents, outdated documents. There could be no sort of link in the chain between old and new documentation. So there's a whole heap of things that we need to be mindful of. And one of those is also the link between the trust deed and the constitution, because what we see is that a lot of funds will set up and they'll have their corporate trustee set up, get their constitution in place, and then they'll happily amend their trust deed along the way, but they haven't made any changes to the constitution, and so there might actually be discrepancy along such things as voting powers and trustee decision-making powers that you want to make sure are being aligned. So, there's some of the risks associated with just having a set and forget strategy with regards to SMSF documentation that we need to be mindful of. Same with when we do then go through the process of undertaking deed amendments and deed updates, what are the ramifications of those updates on any tailored documentation or tailored strategies that we've actually implemented for the clients. So one of the key issues for self-managed super funds over many years has been the legacy pensions. Now, basically one of the requirements for those to maintain legacy pensions was that it had to be provided for within the trust deed. Now, all of those deeds were dated before 2005. And if you've then subsequently had deed amendments since 2005, ensuring that the deed has kept up to date or kept inside it provisions to allow for the payment of those legacy pensions. So just ensuring that the strategy and the documents all match with whatever's been put in place inside the fund. Investment strategies, again, one of the most common talked about documents from an SMSF point of view, and people like myself have gone full circle on investment strategies, from the sense that in the very early days of administration, these were often just thought of as a generic regurgitation of the legislation. And even I think the ATO's thinking, certainly in my early dealings with the ATO, was that they weren't too fussed about investment strategies, sort of, let's say, pre-2007, so pre-superannuation reform, where the industry was probably still in its formative years as far as growth and development is concerned. But now we know that there's a greater emphasis placed on the investment strategy, and not just from an ATO point of view, but from an external auditor point, but also because it's ultimately the document in addition to the deed that is guiding and setting the guiding principles for the members and trustees. So for the trustees to implement strategies to meet the members' needs from a benefit point of view. So, when we contemplate the investment strategy and have to contemplate things such as the insurance requirements, but also sort of as an addition to that, when we talk through things like collectibles and personal use assets and storage requirements. And, we take this a step further, and if the government in their current review look at implementing a retirement income covenant for self-managed superannuation funds, then that would be something that would likely sit similar or alongside an investment strategy with regards to identifying what the retirement needs of the members are and stipulating how the fund is going to meet those needs. Of course, then we have things such as our related party transactions, and we've got this issue around, firstly, around market valuation. So it's really important that funds and trustees document their valuation processes for audit purposes, to ensure that you can see that independence has been incorporated, or at least justification is there for why and how a value has been determined for particular assets. I still make comments around the pandemic and the considerations that went along with it, because what we know is we had this 2-3 year window where we had exclusions or exceptions to the in-house asset rules. And of course, it was really important in things such as related party rentals, related party limited recourse borrowing repayments and things like that. And it's important that all of this was clearly documented and maintained to ensure that from an ongoing compliance point of view, that the ATO don't invoke any sort of look back provisions to go and say, okay, we haven't got this documentation, so when we look at the fund, there's nothing that clarifies why there wasn't any income received this year or why there wasn't any payments made. So it's important to keep that information. And by virtue of that, one of the other key things that we have to be mindful of in that regard is that one of the things that I'll summarize at the end is our record keeping requirements. Whilst we have a record keeping requirement to keep financial statements for 5 years and some trustee minutes for 10 years, well, if you've entered into a limited recourse borrowing arrangement in let's say 2020, and you've straight away jumped into some COVID conditions which have resulted in repayments being a little bit different, the rental being a little bit different. Well, if that loan is going to be over 15 years, then you want to make sure that you've maintained that document for the life of the investment itself. So a lot of these requirements around documentation are obviously moving beasts that we need to be mindful of. Non-arm's length income, clearly there's a focus, how much this focus turns into practical realities from an SMSF point of view, only time will tell. But again, having that satisfaction, particularly from an audit point of view, from an ATO position, is to ensure that all transactions are undertaken on arm's length. And the more that we can justify this by the documentation that we provide in the fund, the easier it's going to be for funds to satisfy their compliance obligations. And as I've stated about LRBAs previously, it's one of those critical things that we need to be mindful of. If we look then at probably the three key sort of life cycle stages of the super fund, because we'll touch on trustee appointment and removals when I work through the deed stuff in a moment. But if we look at our contribution documentation, so things as simple as off-market transfer forms, are we completing them correctly, and are we storing them on file so we can ensure that from an audit point of view, we can see considerations, we can see purchase price or purchase dates, all those sorts of things to be able to reconcile the transaction. Our 290-170 notice of intentions to claim tax deductions, it's important to have these recorded within the fund documentation point of view, if proof is needed to be able to for the members to claim deductions. But also things such as contribution reserving. Now, many of you would have heard me speak before about contribution reserving. I think I may have even spoken about it in our last webinar. But when we talk about the use of contribution reserving in June, so we're fast approaching June now. When we talk about the use of contributions reserves, it's important that a fund documents that process. So the receipt of the contribution in June needs to be documented to identify that amount is going to be allocated effectively to a reserve, or going to be allocated within 28 days following the end of the month in which it's received. And then you need secondary documents to show that that the allocation is then in paper sense at least made in July of the following financial year. But of course, then as far as documentation is concerned, the member is required to request the reallocation from a concessional cap point of view with the ATO. So so many critical document sort of elements within the chain. And what I'm not contemplating as part of today is all of the various contribution elections that need to be made. I'm talking more specifically around the trustee style documents with regards to what obligations trustees have within their fund. Pensions, I'm going to spend a bit of time on them, so I'm not going to spend any time talking about them now. And similarly with estate planning documents, clearly this is the area that's been open to the most litigation, so it's given us the most, I guess, comfort in regards to how we move forward. But still to this day, obviously, it is problematic for a lot of superannuation funds. So let's jump into the trust deeds and talk through a number of the key issues associated with the deeds, and then how that slides away and factors in other issues around things such as our pension documents and our estate planning and investment strategies as such. So generally, self-managed super funds, as we know, they are ultimately operating under both general trust law, but also then under the SIS Act and regulations, and then with links to the various taxation acts as well. So what's important to understand is that we operate under this concept of governing rules. So we don't talk about the trust deed so much within the SIS Act, but it includes a reference to it within the definition of governing rules under Section 10 of the SIS Act. Now, what's important is that the SIS Act doesn't necessarily define for us what requirements need to be within a trust deed. It does sort of set out what our requirements are with regards to how the fund should be managed and how the fund should operate. But of course, what it's important is that the deed itself does not operate outside of the law. And probably for me, the classic example of this was always excess contributions, where people tried to put in powers within the deed to be able to restrict the members or restrict the trustees from accepting certain contributions. And there was a fair bit of toing and froing from the ATO back in the day as to whether or not those deed powers were effective. So, I think a lot of people had them in place for the emergency of large deposits being placed in their super fund, whether or not that actually provided any safeguards for those clients in the event that they exceeded their cap. I mean, I would have thought if you're writing it in your deed and you're going to an extreme level to put it in your deed, then you've already given yourself a warning about not exceeding the cap. So theoretically, that should actually be enough. But it's important to understand that the deed and how the trustees operate is clearly the number one critical document for a superannuation fund. But the SIS Act being the overriding thing of the compliance side of a super fund means that trustees can be held liable for doing the wrong thing, particularly if beneficiaries, and which includes the members, have suffered a loss as a result of the trustees' action. So Section 65 gives that power to take action against the trustees. So ensuring that the deed aligns with SIS, it can be a little bit more restrictive if need be on certain issues, and it can be more expansive as long as it's not going beyond the powers of what the legislation itself requires. So the only real things that the deed requires is two things. One is that that the fund complies with superannuation law, so that's a requirement there within the deed. And of course, one of those things is around the whether or not you've got a corporate trustee or a individual trustees. And if you have individual trustees, then your deed must have the power to pay, or the pension paying powers, which is a constitutional power, which is then imposed upon individual trustees. So that is one of the key requirements with regards to deeds. And then the second one is that whether or not you have them in your deed or not, it's whether the fund incorporates the trustee covenants within the deed. So the legislation is written as such that the trustee covenants under Section 52B and 52C of the SIS Act are included within the fund's governing rules, even if they're not expressly written within the rules. So all of the issues, and many of them you'll know anyhow, to act honestly in all matters, to formulate and give effect to an investment strategy, but things such as the best financial interest duty, incorporating those changes, whether or not they're in the deed written expressly, they do form part of the governing rules of the fund. And again, just to reiterate that point from before, that the SIS Act does void any terms of the deed that are inconsistent with the legislation. So, that's probably a bit of an overview of sort of an introduction to some of the key things about the deed. Let's look more now into some of the key issues that we want to see from a trust deed point of view, because many of you will have clients out there that will have a variety of deeds. And one of the comments that I'll make through the presentation, and probably as I summarize, is obviously that consistency. Coming from an SMSF administration background, you know that when different parties bring different funds under your administration banner, you find yourself in this position where you're potentially operating a lot of funds under a large number of different trustees. And so it's important to make decisions about whether or not you want to have effectively a streamlined deed process. So all clients utilize one deed, you use one deed provider or multiple deed providers, but knowing what the terms are associated with the deeds. But then there are key issues that we want to make sure are in all deeds, to ensure that we have a smooth operation of those funds. And one of the things that you obviously want to see in all deeds is that the establishment date. Now, again, the establishment date is always an interesting concept, because we know from a trust point of view, the establishment date is effectively when you're saying the fund comes into existence, but it doesn't ultimately come into existence until it holds an asset on trust. So there is at least some money held on trust there. So often there'll be a differential there. Of course, in that first year, if there's no money, that's where we have that return not required from a lodgement point of view. The definition of super laws, as I touched on before, the issue associated with the individual versus corporate trustee, paying powers, and that there is a link between the deed and the legislation, and so that the deed needs to be read in conjunction with the law itself. So I've got some references throughout the presentation, which are just references to the Smarter SMSF deed, if you're wanting to question where they're from. Probably a couple of issues that are fairly critical: details for appointing trustees and members of the fund. So I think that's always a go-to area where I'm talking to people and saying, how do we do appointment and removal of trustee? How do we add members? You need to go to your deed, and then you need to determine what documentation is required from that. So I'll come back and work through that in a moment. And then details on how proceedings are to be conducted, such as your voting issues. So again, if you have multiple member self-managed superannuation funds, then clearly, or not clearly, I shouldn't say clearly, the history will show you that from a trust point of view, trustee is a singular concept, and so even if you've got multiple trustees, then the trustee is a singular concept, and so ultimately you need a unanimous decision, but you're not always going to get unanimous decisions. So therefore, you need to potentially have powers written within the deed or the constitution for corporate trustees to determine who has the final say. So if you want to actually go down that path where, if you've got split decisions, then how are they going to be determined when people don't agree? Then you need to make sure that you've got those powers explicitly stated somewhere for ensuring that you don't run into any problems. So let's now look through a number of these management issues and considerations from a trustee point of view. So our requirement is that we need to remain a complying superannuation fund, and our documentation has a bit to do with that. We've got the requirement to hold all assets on behalf of the fund, including entering into contracts in respect to the acquisition and disposal, access to members' benefits only when allowed under super law. So these are all things that you want to see incorporated in the deed. Commentary around regular preparation and reviewing the investment strategy, the retention of records, notifying regulator of changes to things within the fund, and then, of course, certain powers. So powers to allow trustees to lend or borrow money. So this was probably, for me, when you talk about significances of deeds and issues, the introduction of limited recourse borrowing arrangements created a real sort of firestorm of trust deed issues, because in the very early days, none of the banks would allow SMSFs to enter into limited recourse borrowing arrangements or instalment warrant arrangements as they were at the time, primarily because they weren't comfortable with the borrowing powers under the deed. So significant number of hours was put into rewriting deeds for pretty much every deed provider in Australia, sort of from 2007, to incorporate those borrowing powers. So there's a situation now where if you've got funds that have got pre-2007 deeds still, and they're looking at limited recourse borrowing arrangements, then it's quite likely that a lender may not actually want to lend to them because they want to see the deed and what powers there are within them. Accepting contributions, paying benefits, different types of death benefit nominations. As I said, I'm going to come back to the pensions and death benefit nominations. The circumstances around trusteeship, removal and appointment of members, important there. And then other structural changes such as winding up the fund. So it's important that we know what the deed requires when it comes to winding up a self-managed super fund deed. So that then leads to, I guess, the concept of when you're consulting the deed. So you are going to need to consult the deed, and it's interesting. I know I have my own self-managed superannuation fund. I've got a trust deed within that self-managed superannuation fund, obviously. And when I went through certain circumstances, personal circumstances, when I went through separation, I wanted to make sure that the deed had the right powers to ensure that I could do everything accordingly and that I wasn't doing anything inappropriately with regards to removing my wife from the fund and appointing trustees and doing all those sorts of things. So any structural changes, you need to ensure that you're doing them in accordance with the deed. The borrowing provisions, again, there, the income stream requirements. And this is where, as I said earlier, and I probably end up harping on this more than necessary, but I think we haven't seen any real litigation or any real activity in regards to pensions with self-managed superannuation funds. But surely it's not going to be too long until we see court cases that incorporate whether a pension was or was not reversionary and what the consequences of that was from a beneficiary point of view, from a challenging point of view. And a lot of deeds have historically been relatively quiet on pensions, and they would make statements along the lines of a pension can be paid in accordance with the law. And I said 2005, 2006 was quite relevant in regards to your legacy pensions, your compliant pensions at the time, where you had to have specific clauses in there to ensure and by a due date to ensure that the funds could continue to pay those types of pensions. So all of these sorts of issues, anything that's outside the normal activity, or where you think, okay, is it worth checking, what additional documentation might I need, right? Then I'd be going back and reviewing and consulting the deed to see what is necessary. Because again, even things like binding death benefit nominations, you'll see that some people will put those powers into the deed rather than have them outside as separate documentation. And again, you can do the same from a pension point of view. My own commentary around that is that then becomes restrictive if you want to change the terms of pensions, or if you want to change the terms of nominations and allow for other options. Then every time you do that, you're going to need to amend the deed, which is obviously potentially problematic. So yeah, so when we're looking at adding members, there are going to be prescriptive rules as to firstly who can be a member of the fund, but what requirements those members must make, and do they have to provide a member application? And again, if you take a situation like a relationship breakdown, then you've got the legislation that requires or provides for a non-member spouse to effectively be a member of the fund without having to be a trustee, but there's then restrictive timeframes as to how long that will apply for. So having an appreciation and understanding of all those key issues is pretty critical. And of course, if you don't comply with the deed requirements, then the membership may not be valid. And we've seen this with reference over the years, again, primarily around our estate planning cases, where people have added themselves as members to a fund, but they haven't followed the process. And so the courts have determined that somebody is not indeed a member of the superannuation fund. They might be a trustee, but they're not a member, and they need to follow through different processes. But also when you're looking at adding members, whether or not any restrictions apply. And the classic one there is obviously the cure-ops, and anyone that's looking to bring money from the UK to Australia, and the restriction with regards to deeds, and they want fund membership to be restricted to 55 and over. So that's a UK requirement there to restrict to 55 and over, to ensure that money isn't taken out of super that would otherwise be in breach of the UK rules. So ensuring that you're meeting all those conditions there. And then the other side of things is the structural change when you're winding up a fund. So what does the deed require when you wind up the fund, so that you can ensure that your documentation is appropriate when doing that process. And I think whenever I speak about wind-ups, I often reflect back on the fact that the very early days, my early days in self-managed super, there were certain trustees that had references to, because self-managed super funds are indefinitely continuing funds, but they had wind-up clauses which basically provided, because it was an indefinitely continuing fund, that the fund would be wound up. And it's like if there's no members left in the fund would be wound up, following the death of the monarch, et cetera, et cetera. Very, very obscure rules, but this all was sort of steeped in trust law history, and that's how a lot of original SMSF deeds were written. And one of the comments I'll make there, and I'm going to talk about product disclosure statements a little bit more so in regards to pensions, but a number of these structural issues, when we're working through them, what we have to be mindful of is that if we're adding members, but if we're adding trustees or looking to amend our deed, is who has the power to actually accept these conditions. And so most deeds now put those powers in the hands of the member or the trustee, but a lot of the older deeds, because self-managed super funds effectively transitioned from excluded funds before, and excluded funds before were often linked to employer-sponsored funds, so they were set up by the employer, then a lot of these deeds had a founder or a principal employer attached to them. And if you actually reference those deeds, you can't actually make amendments without the signatories of those principal employers, or the founder. And so, whilst you can remove those clauses as part of the amendment process, it can actually delay and create some management issues. So, the whole idea of not buying a deed just off the shelf, it's probably been a common theme now for 10 to 15 years to not just buy a deed without knowing or doing your research on it. And of course, a lot more of the document providers now, I would say most of the document providers now, go to great lengths to be able to identify the key issues that are maintained and retained within their deed, so people can make an assessment as to whether the deed is appropriate or not for them. And again, just sort of to finish on that trustee appointment and removal issue. So I talk about adding members when we're talking about trustee appointment and removal. The SIS Act, and we talk about the SIS Act not being able to be exposed. So legislatively, you have to act within the SIS Act, but the deed can impose further conditions. So the SIS Act states that the legal personal representative of a deceased member or somebody under enduring power of attorney can act in the place of a member. So it's not necessarily mandating that, whereas you can mandate that within the deed. So having those powers within the deed to say that if you're going to appoint the legal personal, or if a member passes away, the legal personal representative of the member must be appointed before any death benefit can be paid out. And again, that can be a way of safeguarding member benefits through certain processes. But again, these are all key issues, and I've got some references there. SMSF ruling 2010-2, which talks about the appointment of enduring powers of attorney. Enduring powers of attorney, of course, are a pretty critical document with regards to the loss of capacity, but they're also critical in the sense that you can appoint an enduring power of attorney to act in your place as trustee of an SMSF, regardless of whether you've lost capacity or not. And many people will often then reference at that point, well, hang on, I don't have that power under the enduring power of attorney. But what this SMSF ruling 2010-2 ultimately stipulates is you're not acting under the powers of the power of attorney, You are utilizing that document to determine who your legal personal representative is. And then the SIS Act is giving you the powers to appoint that legal personal representative in your place, not to appoint someone to act under an enduring power of attorney. It's more the way that the whole process is actually stipulated. So that's one of the key things to be mindful of from a fund structural point of view. Then, of course, from an investment document point of view, we've got to consider things such as our investment strategy. Now, investment strategies in themselves, as many of these subjects are a presentation unto themselves. So what I've provided here is clearly a bit of a references to some key issues that you need to contemplate with regards to a fund's investment strategy. So utilising the deed, utilising guidelines that have been provided by APRA, the ATO, and ASIC with references to a number of the considerations. And one of the key things there, the ATO have got that quick code. They're available to you, and when you get your PDF version of the slides after the presentation today, you'll be able to click on these links. You'll be able to click within the links to take you to those various pages. But the ATO they introduced this in February 2020, and they've been updating it ever since about what their requirements are for inclusion in a fund's investment strategy. And we know that with things such as diversification, that the ATO have taken action. A number of years ago now, they wrote to roughly 20,000 funds who had lack of diversification because they invested almost exclusively in property or asset that were held via a limited recourse borrowing arrangement. And the ATO weren't saying you can't do that. The ATO was saying, do you understand your requirements under the investment strategy covenant to consider diversification? Have you considered it? So they wanted to see people's investment strategies. So again, the ATO don't dictate what an investment strategy has to look like, that they identify that if you've got significant assets in there, that there is reference to that. That if you're using asset pools, if you're using sort of benchmarking, that you're not just making benchmarks from 0 to 100 or whatever, that they are a little bit more meaningful. And it's also not to suggest that a super fund can't go outside that. But if the super fund does go outside that for any extended period of time, then the common sense approach is to review the strategy and to amend the strategy to reflect the new direction that the fund is taking to meet its objectives. So there's a number of key issues that we need to be mindful of with regards to how the whole investment strategy thing operates for a self-managed super fund. And yeah, as I said earlier, I'm as guilty as anybody in the early days of saying that an SMSF investment strategy wasn't worth the piece of paper it was written on, because that's an old school way of thinking, as I said, pre-2007 particularly, but certainly there were the changes that were made in sort of 2011, 2012, and the regulatory changes that talked about the requirement to regularly review the investment strategy. And yes, the question is often, or the comment is often made, not the question is often asked, but the comment is often made that nowhere does it stipulate that the investment strategy must be in writing. But ultimately, the ATO, to me, put that to bed to a degree in this strategy guidance, where they indicate that it should be in writing, because obviously if the fund auditor wishes to see it, then it's much easier to provide them with a copy of the written strategy than to sit down and formulate what is in the trustees' brain. So, it's one of those sorts of legislative anomalies, for want of a better term, where it doesn't use the word written, but realistic, the fact that you need to formulate it, it is far better from a whole process point of view that the strategy is indeed written. Pension documents. So pension documents, as I've said, and I promised this the last time that I'll mention this comment about them being the future potential for litigation in the SMSF space. But because we are always seeing changes with regards to the way pensions are commenced, and again, the retirement income covenant may result in more changes with regards to SMSF pensions moving forward, it's really important that both our documentation and our deed are aligned with what we can do with reference to a superannuation pension. So what we do know, obviously, is that since 2007, right, all pensions that are commenced inside a self-managed superannuation fund must be account-based pensions, right? We also know that you can only start an account-based pension that's a market-linked pension if it's the result of a commutation of a previous lifetime fixed term or market-linked pension. So all pensions must be account-based pensions. And we also know that since 2017, all pensions must be in alignment with the transfer balance cap provisions. So what we then want to make sure is that our deed provides us with the capacity to pay any type of pension that's otherwise allowable within the law. So, to have certain conditions stipulated within the deed about whether or not the pension will be transition to retirement or account-based pension, but also the various documents that are needed. And so what we see here a lot more, and for me, this is something that has certainly transitioned into the industry over the last sort of 10 to 15 years, is we've seen the advent of pension contracts, so or pension agreements. So where the deed will say that the fund can pay a pension in accordance with the terms and conditions of the pension agreement or the pension contract. And then that pension contract will be utilised to specify what the rules of the pension are, which will often then align those rules to the requirements of the SIS Act. But it will make commentary around reversionary pensions. It will make commentary about commutability and those sorts of things. So if you're wanting to put restrictions in place inside a pension, then that would normally form part of those pension contracts that is written in accordance with the trust deed. Other elements that you would contemplate there is how can you make changes to that pension contract? And this is probably the one where we're going to see that, as I said, the issues associated with is, from a reversionary pension point of view, do the terms of the pension allow you to just change from reversionary to non-reversionary or non-reversionary to reversionary. Because if there's nothing stipulated, then the reality is you can't do that. You would have to commute, so stop the pension and start a new pension, and stopping and starting a new pension will have ramifications from a transfer balance cap point of view. It will have ramifications from a tax-free taxable, so from a strategic planning, maybe an estate planning point of view, and it can have ramifications from a social security Centrelink grandfathering point of view that we need to factor in. So ensuring that the terms of the pension as you want them to be, and when I say as you want them, it's not that each trustee needs to have different set of rules if you've got different clients, but you need to have comfort that the processes that you're following for your clients, for your book of clients, all follow a similar process, and that you're comfortable that the documentation stacks up in the event that it's going to be challenged at some point in time, and determining who's going to challenge it. Will it be a party like Centrelink challenging it if there's an issue associated with the loss of Commonwealth Seniors Health Card or age pension? Or will it be a beneficiary challenging it if they feel that the benefit should have been paid to them as a non-tax dependent child rather than a tax dependent spouse? So all of these sorts of things are pretty critical there. So, you know, one of the issues around all of this, and there's multiple, from a documentation point of view, there's multiple documents that we need to be mindful of and take into consideration, is when does that pension commence? So we need to understand when the pension commences, and we've got references to tax ruling 2013-5, which is going through a process of being amended by the ATO at the moment, but around the issues around commencement and that, the rules haven't necessarily changed. So certain things like applications by the members, all these other issues need to be taken into consideration and ultimately stipulated within the pension contract as such. But I can guarantee, if we go back and look at those numbers, I can guarantee you that any pension that is set up using exclusively the software provider documents, right, unless those software document providers are linked to an external document provider, but the generic documents won't have all these issues covered off adequately enough. And largely the majority of pensions that were set up 20 years ago, if they're still in existence, the paperwork was pretty minimal back there, right? So, you know, you sort of started to see the introduction of pension commencement documents, particularly around your complying pensions, but your account-based pension and your terms of your account-based pensions were ultimately restricted to one trustee minute, right? And maybe a member acceptance and member notification. But will that stack up in the future? That's something that obviously we need to be considerate of. So I had this this situation here, and I was going to put up a poll, and I'll still try to put the poll up, and I'll just keep it open for 30 seconds. So hopefully this works. But pension product disclosure statement. So the real question I'm asking here is do you need one? And so if I launch this poll. And there's just the one question there. Do you provide a product disclosure statement with your client pension commencement documents? No, you don't include a product disclosure. Yes, we do, or we give clients the choice to issue a product disclosure statement. And so I'm only going to keep this open for 30 seconds, sort of whilst I work through this, because it's one of those areas where there is an exception within the Corporations Act around product disclosure statements. And so what you'll know is that probably the industry over however many years since these requirements came in, and if I go back and say that these requirements came in around about 2002, then I wouldn't be too far off the mark from a numbers point of view. But if we look at it and look at the moment, our numbers were pretty much, I'm going to end it there. The numbers were pretty much about sort of 56%, so just over half don't include a product disclosure statement, and just under half do include a product disclosure statement. And many people don't give their clients a choice to issue a product. When I say many people, nobody gives their clients the choice as which to do. And so I guess there's a few things that sort of come out from that we need to be mindful of. is that by not issuing a product disclosure statement, have you made the decision that the trustees have all the information available to them to understand all of the risks associated, the pros and cons associated with having a pension inside a self-managed superannuation fund? And so again, if we reference and you go back and look at that article, and I made sure I went and had a look at the article before setting today's webinar up, and it's still there. It's still the most sort of recent article around pensions and product disclosure statements. It really does stipulate that it's still probably in most instances better to have a product disclosure statement than not, just to ensure that the trustees have all of the information they need around the type of pension, the tax, the legal, the actuarial considerations, the advantages and disadvantages, and then the estate planning implications of that as well. So again, without sort of spending too much time digging into issues such as backdating, because let me be very clear that you can't backdate a pension commencement, and that really is coming straight from the horse's mouth from the ATO, saying that a pension commencements once you've got the request to commence that pension, and it can't commence obviously before, or can't commence after payments have been made. Can commence before a payment has been made, and of course payment terms can be made on an annual basis. So what we're tending to see more and more providers doing now is providing pension commencement documents, or at least initial resolutions around the commencement process without the final numbers in them, because often the final numbers are required once the financial statements have been completed or whatever evaluation's done. But you at least want to start the process off by triggering the pension commencement, saying that I, Tim Miller, want to commence a pension on the 1st of July, and today is May, and so therefore I am putting in place that request to do it. So the trustee or the member is notifying the trustee, rather than going back in time and creating the concept of backdating, which we need to remove from sort of our mindset with regards to pension documents. And then the other key thing around pensions and documenting important decision-making process is the whole concept around payment and payment discretion. So, we know that we have our minimum pension obligation, and the obligation of the fund is to pay the pension. But again, I've provided some links to the ATO there where they're talking about those people with multiple pensions, and subject to the terms of how the pension's set up, and subject to whatever documentation's in place. Like if you've indicated that you're going to draw X amount from one pension, you've got multiple, and then you haven't met the minimum from the other pension, then if your documentation is stating that all those payments are to go to pension one, then you can't just make an assumption that you can move money from one pension to another to meet the minimum obligations of both. Now that, to me, it's a little bit ludicrous in that sense, but what I would be suggesting is that the better way to do it is to ensure that the documentation that you create and potentially get your clients to sign off on each year is to say that the first obligation is to ensure that the fund meets its pension obligation for all pensions, and then to have specific instructions in place for any payments in addition to the minimum pension obligations being made. So ensuring that you're documenting the requirement to take amounts as a lump sum from an accumulation interest, or as a partial commutation from a pension. So considering those sorts of issues there. And then looking at what other gaps there are. So again, reversionary beneficiary, whether or not that the level of reversion is going to be 100% or less. Now, again, in 25 years, however many years I've been doing this now, every pension I've ever seen has been 100%, but that doesn't, it's not a legislative requirement that it has to be 100%. In other ways, it's a little bit around, like, do you leave a binding nomination rather than a reversionary pension, and say that you want 50% of the pension to go to a spouse and the other 50 to be paid out to a child. All of that can be done and can be accommodated as long as the documentation for that matches up with the client's need and is within the contract rules. But other things as well, such as asset segregation. And asset segregation, similar to pension commencement, is a prospective, not a retrospective strategy. And so you need to stipulate or state prior to the pension commencement, or if you're going to do it from 1 July in a year from that date, if you're going to implement an asset strategy or an asset segregation strategy as well. And then the other thing is the signing capacity. And I talked about enduring powers of attorney before. And this is where the powers within the pension contract, but also the powers within the actual enduring power of attorney can be important, because if you provide your enduring power of attorney with specific powers to make decisions about your superannuation benefits and the payment of pensions, and that's written within the enduring power of attorney, again, you want to ensure that you're getting appropriate legal advice on that. But then that would give your EPOA the capacity to act in their EPOA capacity as opposed to their trustee capacity to make membership decisions about the payment of pensions. So it's all pretty critical in that regard. And just to summarize all of that is really the piece around benefit payments and ensuring that the deed and then your documentation can provide for things such as in specie payments, because we know you can't do it for pensions, but whether or not you can do it for lump sum withdrawals and death benefits, you want to make sure that one, it's provided for within the deed, and two, that you're documenting it and documenting the valuation side of things with regards to the paying of benefits out. So look, I'm not going to spend too much time on the estate planning side of things. Again, I've just made a few references in here for you around what we need to consider, because from an estate planning position, and my June webinar is going to be on insurance inside a self-managed superannuation fund, and in the July webinar, I'm going to do estate planning. So I'm going to spend a lot more time with you in July working through the estate planning issues. So really the key here is ensuring that knowing the tens of, I won't say hundreds of funds, but the tens of court cases that we have seen in the SMSF space around death benefit nominations, binding nominations, and who has what power. What we ultimately know is that Hill and Zuda has said, from a High Court point of view, that it all comes back to the trust deed, right? And the trust deed gives us that ultimate power to be able to dictate the terms of our binding death benefit nominations. And so that's pretty critical for us to ensure that we're not focusing on things such as the 3-year validation rules and all those issues, which of course we can do if we want to make terms within our deed that say that a binding death benefit nomination is allowable only in accordance with SIS Regulation 617A. But that's going to be an area that most people don't want to sort of focus on too heavily and pretty much try to avoid. So let me finish off now by talking and taking you through some of the key issues around both signing and storage, because this is an area that we've certainly spent a fair bit of time on. Particularly Aaron Dunn, has been involved with the tax office and with Treasury, working through a lot of issues associated with electronic execution and understanding the Electronic Transaction Act. Now, the one key thing about the Electronic Transaction Act is that it applies to Commonwealth legislation unless the legislation is specifically exempted by the regulations, and the one act and regulation that is primarily still exempted is the SIS Act. So what that means is that from a SIS point of view, or from a superannuation point of view, the only pieces of the only documentation where we can electronically sign without due consideration for any other purpose is our accounts and statements. So our signing requirements, which require at least one or two or half, whatever the number is, of trustees to sign, and then we've got our storage requirements there. Now, of course, if you're using electronic signatures, then everybody has to have their own email to be able to sign appropriately. So it's fairly limiting in what we can actually do. Whereas if we look at other issues, our in-house asset written plans, our duty to record or keep minutes, our trustee declarations, our consents to appointment, a storage of collectibles and personal use asset, and our investment strategy, it is not specifically written as to what we can and can't do there. And so therefore the decision has to be made based on what's written within the deed, and what would also be considered as normal process and acceptable process. And part of that normal and acceptable process is going to be a little bit about what will the auditor accept as well. But given that a lot of deeds won't necessarily have anything written in there about how documentation should be stored, then you've got to have to weigh up the risk associated with whether things are done electronically, so like pension commencement docs and things like that, whether they're signed electronically or whether you need a wet ink signature. So again, not saying that you can't have these documents signed electronically, but one, if they're needing to be produced from an audit point of view, how do you go about that? Is it easy from a storage point of view? Are you comfortable with the storage requirements there? So we've kind of looked through and done a bit of a risk analysis of whether or not certain documents should be done electronically or via wet ink. And obviously certain things such as adding and removing trustees and members, there's a bit of a risk associated, a higher risk with that being in electronic form. Pension commencements, lump sum and income stream based events, at the moment, there's a high risk because one of the key issues, and you can say this about signed documents as well, but from a storage point of view, if there's an event that occurs and it's not stored centrally and everybody is not aware of that, then if there is an inability to prove the set of circumstances, then it can draw out what could otherwise be relatively simple processes if the documents are provided as part of the standard signing process, and a paper copy can be held and maintained for everyone. So look, again, realistically, it's one of those key things about from a record keeping point of view, understanding what your requirements are with regards to what you need to keep for 5 years or what you can keep for 5 years. So primarily your accounting records there, and what needs to be kept for 10 years. So your trustee minutes, your trustee declarations, your consent to act as trustee, your storage of collectibles and personal use assets. But one of the key issues around that is, these documents that you need to keep for 10 years is, should they actually be kept for longer? So, as I highlighted before with the limited recourse borrowing arrangement, but you take reversionary pensions, you take binding death benefit nominations, obviously all of these sorts of documents should be stored for 10 years, but they also shouldn't be destroyed after 10 years because the pension might still be on foot, and you want to ensure that you've got that documentation on hand when an event actually occurs that's going to require the documentation to be reviewed. So a lot of that stuff is not new issue from a superannuation point of view. We're all aware of the 5 and 10 issues, but really, and I guess for me, the key messages to come out of today is that there's still a lot of stuff in regards to SMSF documentation that wouldn't pass the smell test from an audit point of view. If you have to change auditors and you move from an auditor where you've had a long-standing relationship with, and they've potentially sort of been a little bit easier on you with regards to the documentation you provide, and you move to a new auditor. And I know that clients I've dealt with in the past, like, why is the auditor asking for this after 15 years? Or why is the auditor asking for this after 10 years? Like, well, okay, well, there's been a change in auditor, or they've been audited by the ATO and therefore have changed their circumstances. So they now require it to make sure that the fund is complying. And more often than not, when I've seen auditors asking those questions, there's been some reason why, and often that is a compliance issue that's linked with the transaction as well. So again, not suggesting that deeds have to be updated all the time, but there's certainly scope to suggest that every 5 or so years a deed should be reviewed, particularly when there's so much legislative change as well. I mean, if you go through long periods of no legislative change, like say from 2007 to 2017, then arguably you could have retained a deed for that entire period. But it's always worth reviewing the deed just to make sure that it satisfies all the conditions. So ensuring that you're familiar with the powers that the deed provides for, ensuring that the deed and your death benefit documents marry up with regards to what the requirements are. Similarly with your pension documents, but also importantly with your succession rules and your voting powers and your constitution versus your deed are all pretty critical things to contemplate. So look, I'm not going to spend any time talking about this today, but I wanted to include it in the presentation for you to be able to review. But we do at Smarter SMSF have a document service that we provide. There's both a PAYG and a subscription-based one. What you can see from everything here is that there are different sort of situations that apply based on whether you go PAYG or whether you do subscribe. Our subscription packages are based on effectively how many documents you're going to utilize, 25, 50, 100, depends on your clients as well, and there are costs there. But as I said, that's I've just provided that information for you all, and if you've got any questions, I've also provided David's details, and you can contact David to discuss any of these things. But I've listed there, provided you with a list of what we would provide or what we're able to provide for things such as various pension documents. So finally, just a bit of a plug. We've got Aaron and myself do 3 online masterclasses a year. We've got one coming up in June on property, which includes limited recourse borrowing arrangements. These are interactive, so if you want to be involved with that and you want to sort of get a bit more CPD, then what we're offering for this week is effectively an early bird or a webinar special that you can save 20% off the non-member masterclass price. If you are a member, then the masterclasses are incorporated. But by all means, if that takes your interest, then please follow that link. Otherwise, as I said, 18th of June, I'm going to talk about insurance in a self-managed superannuation fund, and the 23rd of July, I will do a session for you on SMSF estate planning considerations. So thank you all for attending. As I said, it was a rapid fire presentation today, a lot to get through, but I wanted to put all the material into the slides for you to be able to sort of sit back and review afterwards. So then you can sort of go, okay, well, what do I need to potentially, where do I need to improve my practices or whatever with regards to how we're operating for our client base. And if we can be of any assistance in that, then by all means, reach out. So thank you for attending, and I look forward to catching up with you in our June webinar. Bye for now.